Yes, welcome to our talk on remedies on adjustments. My name's Sarah Brewis. I'm a barrister at Park Lane Plowden in Newcastle. I'm joined by Bethan Davies. She's also a barrister at Park Lane Plowden in Newcastle. We specialise in employment law. We were asked to cover a talk on remedies and in particular adjustments. So Sharon, our clerk, suggested that we might want to cover this. So as you can see from the slides, and we will circulate these afterwards, we're going to spend about 30 to 40 minutes talking about POLCI, ACAS uplift, contributory fault, and then the order of adjustments. So to get us started, POLCI case, I mean, it's probably, other than Birchall, the most well-known case for any employment lawyers from back in 1987. And the principle that the compensatory award can be reduced or limited to reflect the chance that the claimant would have been dismissed in any event and that the employer's procedural errors accordingly made no difference to the outcome. So as I've set out here, as we all know, it can be expressed as a percentage reduction of up to 100% or as a cap on future loss. And the two approaches are, first of all, where the tribunal is certain that dismissal would occur at a point in the future, a time-limited award is appropriate. So, for example, if the tribunal expresses certainty that the claimant would have lost his job in any event in 6 months, that would limit compensation to 6 months. But alternatively, if there's any doubt as to whether or not the employment would continue, percentage deduction approach is the sole appropriate means of reflecting this uncertainty. And I think most of us are probably more familiar with the percentage reduction approach. I've said at the end there, as an alternative, there can be a combination of the two approaches, but it cannot be in the same period of loss. So the Zabrowski against Concentric Birmingham Limited case it's a case from 2017 where the EAT gave some pretty helpful advice on the proper approach to a POLCI reduction, because at first instance in that case, the tribunal had determined that there was both a 60% chance that the claimant would have been dismissed but also within 2 months of the date of dismissal. So that sort of double, I call it a double POLCI. When the case went to the EAT said that that was an error of law and that that was a double POLCI and it wasn't appropriate. And it set up the guidance that in essence I've expressed in that slide. So in terms of a certainty that a dismissal would have occurred, what the EAT said is that where the tribunal is 100% confident that a dismissal would have occurred within a certain period, that approach is appropriate. That's the time-limited approach. But otherwise, it is the percentage deduction approach, which is the appropriate way of calculation. And it made clear that what's not permissible is the introduction of a long stop date and then the application of a percentage deduction to reflect the prospects of an earlier dismissal, because again, that applies the same principles twice. So if we go on to the next slide. So Lord Bridge obviously was, this is in the POLCI case itself. He set out 3 possibilities where a POLCI reduction is contended for. First of all, a finding that there was no chance of a dismissal and therefore no deduction. Second of all, a finding that an employee would have been dismissed in any event and therefore no award of financial loss. Or finally, a finding that a dismissal was not certain, but there was a substantial chance of the same, and thus the employee's losses are reduced to reflect that possibility. So as I said at the end, a tribunal could and should reduce the level of compensation if the employer, and obviously the burden is on the employer, not normally the respondent, to show that the present outcome would have been the same, even if they had followed a fair procedure. And just finally, there, it's the actions of the actual employer that are relevant, not a hypothetical employer. So we're not looking at reasonable bands, we're looking at what the actual employer would have done. So looking at the next slide. The tribunal in its task has to assess POLCI deduction as follows. First of all, if a fair process had occurred, would it have affected when the claimant would have been dismissed? And secondly, what is the percentage chance that a fair process would still have resulted in the claimant's dismissal? And then on the next slide, I've set out, really it's a very speculative task that the tribunal has to embark upon, and that's laid down really in the case of Thornett and Scope from 2006, whereby Lord Justice Pill made clear that the statutory duty of the tribunal does involve making predictions, and tribunals cannot be expected or even allowed to opt out of that duty because their task is a difficult one and may involve speculation. And Lord Justice Prosser, in the same case, had said that a tribunal should only decline to embark on that speculation where the circumstances are such that one cannot sensibly reconstruct the world as it might have been. So now I think, Bethan, you're going to talk about ACAS codes with uplifts and reductions.
I am indeed, and ACAS codes not just the next step for us, but would be the next step, the exact next step for a tribunal if they were performing this exercise. So the starting place is section 207 of the Trade Union and Labour Relations Act 1992, we can see on the screen, which provides for the admissibility of the relevant codes either issued by ACAS or the Secretary of State in all tribunal cases. The next relevant section is section 207A, which is where we have the provision for the adjustment of awards, so either an increase or a decrease, depending on which way you're looking at codes. And a few general points to note here before I get into what I want to focus on, which is the application of what I think is the most important of the codes, the disciplinary and grievance code. Perhaps not the most important, but the one that we come across most frequently. A few general points: the adjustment applies only in the cases that are listed in Schedule A2 of the Act. Very briefly, that's going to cover most of your what you might say normal claims, so your unfair dismissal, both constructive and automatically unfair, unlawful deductions from wages, detriments claims, and your Equality Act claims. It might be sometimes we come across something that might be a more unusual cause of action, always worth having a look at the schedule. The adjustment applies only to the compensatory award, not to your basic element. The breach must be unreasonable. You can see that in 2A and then the equivalent 2C and the equivalent 3C. So a breach per se does not give rise to an adjustment. There is very little appellant case law on what is unreasonable in these contexts. There's clearly a broad discretion upon the tribunal here, and really I think you're going to be looking at questions about whether or not it's just a breach in form rather than substance. As to the increase or the reduction, that increase must itself be just and equitable. Again, there is very little appellant case law on this, but what is clear is that that assessment of just and equitable has to be reasoned by the tribunal, and the tribunal would be falling into error if they do not set out their reasoning as to how they've made that assessment of just and equitable. What we do find in the case law is that the tribunal cannot be punishing the respondent, or I suppose conversely the claimant, for circumstances other than the breach. They cannot take into account factors that are external to the employment relationship. And what is relevant is the extent of the breach, the intent of the party who has committed the breach, and mitigating factors, such as, for example, a respondent in financial collapse who doesn't have the resources at that time to follow the code. I've interchangeably referred to the code and the codes. I think it's worth just noting the statutes refer to which a relevant code of practice applies. So it doesn't refer to the code of practice, and it doesn't more specifically refer to just the disciplinary and grievance code of practice. There are 5 codes of practice. I think as employment practitioners, we probably use the code as shorthand for what I'm going to refer to as just code 1 rather than going through the lengthy name of the code. All of these codes are issued under section 199 of the Trade Union and Labour Relations Act by ACAS. They therefore all come under the admissibility provision of section 207 of the 1992 Act. And I certainly think it follows that they then all fall under the scope of 207A in respect of the fact that you could make uplifts or deductions in reference to all of these codes. Strangely, if you read the codes themselves, only code 1, the disciplinary and grievance code, makes any reference within the code to an uplift. IDS from what I can find, is silent on uplifts for the other codes. Harvey tells us we can have an uplift for code 1 and an uplift for code 3, but is silent on 2, 4 and 5, other than to say, as I have said, that they're all issued under section 199. I have never seen a case myself where there's been an uplift in respect of the other codes. I think it is very easy to imagine a case where code 5 is in play on reasonable flexible working requests, and it's very easy to see a case where you could be successful in, say, an Employment Rights Act claim in regards to flexible working request, and therefore the code would be engaged. I have searched through reported cases fairly briefly, but in any event, search through reported cases on the government website for successful flexible working claims, and can't find the code mentioned in them. So I'd be very interested if any of you, perhaps after this, if anyone has had the case where you've managed to get an uplift, say for code 5. I'll come back to it in a minute, but I certainly think it's an argument worth making. But it's certainly relevant and helpful to remember that there isn't just one code. That being said, I do want to focus on code 1. I've said I think it's the most important or salient code for most of us. It's what we'll come across most frequently. And what I'd like to focus on is the application of the code, because there have been a couple of recent cases which I would say expand the application of the code. When you start to read the code, this is clearly paragraph 1, and it seems like it's straightforward where it applies to disciplinary situations include misconduct and or poor performance, and then we all know what a grievance is. Simple, right? As is often the case in employment law, perhaps not quite as simple as it first appears, or perhaps as we would want it to be. So the first of the recent cases is the 2022 case of Rent Plus and the EAT. Very briefly on the facts, the claimant was unfairly dismissed, and the tribunal found as part of a sham redundancy. The real reason for her dismissal was to remove her so that she could be replaced with a named individual because of dissatisfaction with her personally and with her performance. The tribunal at first instance found that that dismissal was also an act of direct sex discrimination. She had also raised a grievance that the tribunal found was dismissed as part of a sham grievance process. In the first instance, a 25% uplift was applied in respect of the dismissal. And the respondent appealed on the basis that the respondent's given reason for the dismissal was redundancy, and the employment tribunal's finding on the reason for dismissal was sex discrimination. So the respondent argued that therefore the code did not apply. And in short, the tribunal gave short shrift of that argument. They found that it didn't matter what label the respondent applied to a dismissal, nor did it matter that the employment tribunal had found that the dismissal was an act of sex discrimination. Because of course, there isn't a binary between something being an act of discrimination for any protected characteristic and there being an element of performance or misconduct, and a dismissal can have multiple bases. The reality the EAT held was that you needed to focus on what the dismissal results from. Is it concerns about conduct or poor performance? If so, then the code applies, regardless of what label the respondent, in essence, how the respondent has dressed up that dismissal. And then in 2023, we've got another EAT decision, an SPI Spirits, in the context of automatically unfair dismissals. The claimant was an employee of the first respondent, and the second respondent in this case was found to be an agent of the first respondent. The tribunal found that in a telephone conversation, the second respondent had subjected the claimant to a detriment and dismissed him on the ground that the claimant had made protected disclosures. The employment tribunal found that the claimant was subject to an automatically unfair dismissal, perhaps unsurprisingly, but they concluded that the disciplinary provisions of the first code did not apply, but that the grievance provisions did. And in making this conclusion, the employment tribunal stated, a protected disclosure can never in itself be a ground for disciplinary action, i.e. a ground for an allegation involving the culpability of the employee. Importantly, there was no disciplinary sham in this case. In fact, it was the respondent's case that the claimant had in fact never been dismissed by them. The respondent appealed on various bases, including in regards to an ACAS uplift that was applied in respect of the conduct of both of the respondents. The Employment Appeals Tribunal, they held that if an uplift could, part of the claimant's argument was that even if the Employment Tribunal was wrong in respect of the uplift for the grievance, that the uplift could have and should have been made for the disciplinary aspect of the case, and as such the Employment Tribunal had come to the right outcome in any event. And in engaging with this argument, the Employment Appeal Tribunal held that if the uplift could never be made in an automatic unfair dismissal case, then the same claimant in the same facts who succeeded on an ordinary unfair dismissal claim would have the benefit of the code and eligible for an uplift, but would be in a less beneficial position if their dismissal was found to be automatically unfair, and that of course doesn't make sense. And in coming to that conclusion, the AT stated, the employee should be able to enjoy the procedural safeguards of the code, whether their case is that they're simply not guilty of the culpable conduct, or more than that the conduct in question amounted to the making of a protected disclosure. The discipline provisions might apply if, for example, in a given case, the tribunal found that the issuing of a written warning was materially influenced by protected disclosure and no fair process had been followed. So the real question for a tribunal is, has the employer taken action against or dismissed an employee because of the respondent's perception of culpable conduct? It does not matter that whistleblowing is not itself culpable conduct. The question is whether the respondent is treating it as culpable conduct. And if they are doing so, then the code applies. And of course, if we stand back, that must be right, because when we apply the code in normal situations, we're not asking questions, wrongful dismissal type questions of whether this claimant was actually guilty of misconduct or poor performance. We're asking whether they have been tracked to be. So it's clear really that the same should apply in respect of whistleblowing situations. I think there are a few points to take from this. The upper tribunal seems to be applying the code in a purposive way, looking at the substance rather than the form and generally expanding the scope. I think if you're for claimants and you're in a dismissal claim, an automatic unfair dismissal claim, a discrimination claim, or an act of discrimination is dismissal, you should plead the code if there's any suggestion. In essence, the respondent is punishing the claimant for something they have perceived that the claimant has done which they shouldn't have done. I think that's a very broad circumstance in which you can plead the code and should be doing so. That being said, please identify which part of the code that you're saying, or try to identify which part of the code you're saying has been breached. If you're advising respondents, I would say that really they need to be advised that they need to be following the codes, or at least the general principles of the codes, regardless of what label they're putting on a discrimination, a dismissal, apart from those dismissals that we know clearly fall outside of the scope of the code, so redundancy and ill health dismissals. And then in regards to the other four codes, well, again, I would say plead them, particularly the flexible working code. It seems that you should be able to get an uplift there. One last thing before I hand back to Sarah. The Secretary of State was obviously knew that we were doing this talk today, because on Tuesday, the new draft code of practice for fire and rehire was published. It needs to be approved by Parliament, but it's there on the Parliament website. It should be, one expects, incoming within the next perhaps year or so. So want to keep an eye on.
Thanks, Bethan. So I'm going to deal next with contributory faults, and you may have noticed that we're dealing with adjustments in the same order that the tribunal has to deal with them, which Bethan will come on to in a moment. And we've chosen the three most frequently sort of argued adjustments that you come across in tribunal claims. Contributory fault, interesting to note that, of course, we always think about contributory fault in relation to basic and compensatory awards, but it also applies to potentially detriment, the right not to be unjustifiably disciplined, the right not to be expelled or excluded from a union, part-time worker discrimination, and fixed-term employee discrimination claims. And as I've said at the end of the slide there, also potentially to wider to discrimination claims and injury to feeling awards, and that's following the decision of Way in Another against Crouch back in 2005, which really was authority for the proposition that it could apply to an injury of feelings claim. But that to some extent has been dismissed by First Greater Western Limited and Linley against Wayego. I'm not sure if I'm pronouncing that correctly, but a case from 2018 where Mr. Justice Kerr expressed misgivings for the proposition suggested in Way in Another against Crouch. And in the First Greater Western case, the claimant in that case it was said that she'd been contributory negligent for failing to provide details of her previous CBT treatment. When the case reached the EAT, Mr. Justice Kerr said the notion of contributory fault and discrimination was, and I quote, perilous and difficult to apply because it predisposed that the victim had, by blameworthy conduct, contributed to the unlawful act of discrimination against her. And he went on to talk about how one could only consider the example of sexual harassment to see how dangerous this notion could be. He further said that he pointed out there's no provision for reducing compensation by way of contributory fault in the Equality Act, so we have to think about the intentions there, and also that discrimination can be committed without fault, for example, in the case of unconscious bias, for example. So what I would say is, although it's feasible or possible that an injury to feelings award is reduced for contributory fault, I think really we have to treat that with a large amount of caution. It's certainly not an argument that I've never made or would feel comfortable making, I don't think. I suppose in theory, if there was a claim for both discrimination and an unfair dismissal, a deduction for contributory fault could be applied to both compensatory awards, but I would say that would only be if those compensatory awards were inexplicably linked. That would be the only way that I could see that it would result in a deduction. And just going back to what Mr. Justice Kerr also said in the First Greater Western case, he suggested that if there was an argument, for example, that a failure to keep a medical appointment was contributory fault, well, that might be better addressed as a failure to mitigate loss argument rather than a contrib argument per se. But worth bearing in mind, although in practice I suspect it's very unlikely to see. So next, just dealing with the difference between section 122(2) and 123 of the Employment Rights Act, because although both sections of the Act deal with tests about what's just and equitable in terms of reducing any award, for a basic award, of course, it's any action prior to the dismissal can be viewed with regard to reducing the award, but with the compensatory award, the conduct has to be connected with the dismissal itself, and because of that, the awards have to be considered separately from each other. And then on the next slide, claimant's conduct must be culpable or blameworthy. I often refer to a very old case from 1980, Nelson against BBC number 2, because that sets out, it's a really useful analysis of what culpable or blameworthy means, and it sets out sort of reductions, for example, 50%, 75% that might be appropriate and when that might apply. I often use that in skeleton arguments. But some sort of guiding principles for a compensatory award: the conduct must cause or contribute to the claimant's dismissal. Secondly, it need not amount to gross misconduct. Thirdly, if it's not a dismissal for misconduct, it's unlikely there will be an adjustment because the conduct needs to be reviewed as blameworthy. So, for example, I've set out there, it's unlikely to be appropriate for a poor performance, incompetence, or ill health dismissal. For example, an ill health dismissal, I think you'd struggle to say that the claimant had caused or contributed to their own dismissal. That might be a difficult argument. And then finally, reduction can be made even if, had the employer acted fairly, a dismissal would not have occurred at all. And that's a case from last year, Wilson against DVSA from the EAT. In that case, the claimant was dismissed from his job as a driving test examiner after he'd driven home the car of a student who he'd already failed and who he considered unsafe. That was contrary to the respondent's examiner guidance. To make matters worse, this claimant didn't tell his manager about the incident, and his manager found out by chance 7 weeks later. After an investigation, claimant's dismissed because the respondent said the trust had been irreparably damaged between employer and employee. The judge in the first instance case found that the investigation process had been flawed and the dismissal was unfair, but he found that because the claimant was wholly the author of his own misfortune, partly because he was also a former police officer and knew the importance of following the rules, it would be inequitable to make any compensatory award. Well, this case went to the EAT, and the Honourable Lord Fairley allowed the appeal partly because he agreed with the submission that to reduce the award by 100% was perverse when the investigation had been flawed, though he did find that it was open to the judge to make such a reduction. So he remitted that case back to the employment judge for the reconsideration of the awards in the case. And then the next slide, the principles in assessing contribution primarily come from Steen against ASP Packaging Limited, again an EAT case from 2017. Tribunal should should first of all identify the relevant conduct. Second of all, assess whether it's objectively culpable or blameworthy. Thirdly, consider whether it caused or contributed to the claimant's dismissal, and if so, fourthly, determine to what extent it is just and equitable to reduce any award. And just finally, from my perspective, overlap of Polkey and contributory fault. I find certainly in the past, I found that judges were perhaps less interested in considering this than they are now. But the proposition for how tribunals are, or the approach for how tribunals are to deal with this comes from a 1994 case called Roa and Civil Aviation Authority, and how the tribunal should address the question of remedy when both Polkey and contributory fault reductions are contended for. And the approach that was suggested in that case was, first of all, assess the loss sustained by the employee in accordance with section 123(1) of the Employment Rights Act, and that will include the percentage reduction, if appropriate, to reflect the chance that he or she would have been dismissed in any event. So that's your Polkey. And secondly, the tribunal should then make a deduction if the findings are there for contributory fault. But what the authority says is, in deciding the extent of the employee's contributory conduct and the amount by which it is just and equitable to reduce the award, for that reason, under section 123(6), the tribunal should bear in mind that there's already been a deduction under section 123(1). And I've mentioned two other cases there, just because I do find personally that tribunals are more interested in this now. But they're keen to avoid the risk of penalising the claimant twice for the same conduct. So the Lennion UK case sets that out. There's also a case from November of 2023, EAT case, where this arose. It was an appeal on a number of grounds, but in essence, the claimant at first instance had been awarded £41,000 in compensation, and that compensation had been reduced by 75%. By way of Polkey reduction. Now, the first respondent appealed and said that there should also have been a reduction for contributory fault, but the judge disagreed and said, well, no, because there was a risk of double counting if a deduction for contributory fault was also made in addition. So that is something that I think more and more we're seeing in tribunals consider. So just worth considering that claimants should not be penalised twice. Bethan, I think you're going to deal with the order of adjustments next.
Yes, just for our got an eye on the time, our last few minutes. So this comes with a bit of a health warning, as is often the case with technical things like this. It's dry, and I think it's fair to say it's fairly boring. So I think we should keep it short and sweet. In the main, I don't think that you need to know the reasons why adjustments go in various orders. What's most important is to know what order that they go in. So when we send you these slides, you can pinch this flow chart and you've got a little crib sheet as to what order that they go in. There's a helpful rule of thumb. The key case is digital equipment, as you can see on the slide. helpful rule of thumb is deductions before reductions. So you make the calculations to come to the claimant's net loss. So by deducting the specific sums that they have received from the employer, so as notice pay, enhanced redundancy pay, sorry, not enhanced, statutory redundancy pay, and then also the sums that they have earned through mitigation. And then once you have applied those deductions, you then start to make the reductions, i.e. percentage reductions. So starting with your just negligible, including your POLKI, then your ACAS code, then an uplift for written failure to provide written particulars, then any deduction for contributory fault, any deduction for whistleblowing being in bad faith. You'll see the little arguably there. That's because there isn't actually anything that's particularly clear authority on where the whistleblowing bad faith should go, but the consensus is that as a common sense reading it should go there. And then you remove the enhanced redundancy. That's because the rationale behind enhanced redundancy being there is that the respondent should get the full benefit of the sum of redundancy payment that they've made above and beyond the statutory minimum. To put it bluntly, that sum shouldn't be messed with, it shouldn't be reduced, and the respondent should be put at some sort of hardship because of that. And then you apply the statutory cap. Very briefly, why does it matter? You can see from just a very simple working out on the screen. I've said we've got a claimant, Bob. He has been successful in his unfair dismissal case for an unfair redundancy. Bob's awarded £10,000, and you can see if you work through the deductions and reductions that need to be made to Bob's award, so taking off his statutory redundancy, his enhanced redundancy, making a POLKI deduction, he doesn't get an ACAS uplift. He has had a 2 weeks uplift for no written particulars, and he's had a 20% contrib. You can see if you do it in the right order, the sum that you get is £4,620. If you do it in the wrong order, and in this instance I've taken off his full redundancy, including the statutory redundancy, and then we made a mistake about where his contrib falls, putting that before POLKI rather than after the written particulars, you'll see in that instance Bob's coming out better off at £4,900. You might say, well, it's not that big a difference, but it's easy to see how, if you're dealing with significant sums, you are either, and it's not always going to be the case that it benefits the claimant, it depends on the specific circumstances, but it's easy to see how you could be making a significant error in those calculations. So in short, look at that little flow chart, and hopefully that's all you need for most cases, unless it wasn't particularly gnarly and complicated. That brings us to an end. I think we said that we'd be half an hour. On my watch, we've been about 35 minutes. So thank you all very much. We've included on the slide our email addresses. If anyone wants to email me and tell me that you've had a case with an uplift for breach of that, perhaps code 5 or one of the other codes, I'd be very interested to hear about it. And we can always be contacted at Newcastle Chambers. Thank you, everyone.